So first of all, I want to go to judicial case management reforms. One phenomenon that has really abounded, and I think in a stunning way, in the last 10 years has been the increase in judicial case management. For the younger lawyers in the room, it is probably very difficult for you to contemplate what life was like without directions, hearings, case management, let alone the impact of the Civil Procedure Act. We fairly much now, across the Supreme Court, have difficulty indeed in contemplating any case that would not have gone through appropriate phases of judicial management before it reaches trial before a judge. Underlying that intensive judicial management is alternative dispute resolution. That is another significant change that has occurred in the last 10 years. Of course, mediation is an obvious one, and for most of us, we can't imagine litigation without a round of mediation along the way. Virtually no case in the Supreme Court goes to trial without at least one reference to mediation, and sometimes there are multiple references. Combined with the obligations now under the Civil Procedure Act, this has only increased. But in addition, and some of you will have experienced this, judges are able to use mediation as a tool in the course of managing a trial. In the days when I sat in the commercial cases, sometimes I would hear a case for a few days, and then there would be what I have described as the sweet moment, where you would know that the plaintiff's case had started to take shape, the defendant knew how things were lining up, the key witness might have been about to get into the witness box or might have just stepped down, and there was just the right time when, as a judge, you could say, perhaps the parties might prefer that I not sit tomorrow so that there's an opportunity for discussion, waiting for a response. Perhaps the parties would be assisted by mediation, and more often than not, parties would grab the opportunity. But sometimes there are reluctant players, and that's where we have a resource within the Supreme Court that is absolutely invaluable. Many of you will have been assisted by the opportunity to access mediation through the Associate Judges. Associate Justice Randall is here this afternoon, and His Honour, along with other colleagues, play a pivotal role. They have managed to assist parties in resolving the most difficult, complex litigation. The other important feature of judicial case management flows through not just to trials but also to appeals. We, sitting on the Court of Appeal, will regularly refer the parties to mediation before we will allow the appeal to be heard. Recently, having sat on an appeal, at the end we put to the parties that one appellant was urging that we remit the matter if the appeal was to be upheld, and in the context of the case we encouraged the parties to go to mediation before an associate judge. That eventuated. The matter's yet to be finalised, but there we have trial, judgment, appeal, judgment reserved, and what would seem to be quite completely off the page, we referred the matter to mediation. So that of itself indicates the flexibility of the court and its direct involvement in assisting parties to resolve their disputes. In passing, I must not neglect to mention the cost court. That is a new phenomenon here in Victoria. It is exclusive to Victoria, where we have a specialist court with specialist judges expeditiously resolving costs dispute. And that of itself, as we know, is a very significant aspect of litigation, often forgotten but very important. There have been reforms too that facilitate greater recovery of costs in taxation.